And this case is huge because it's going to have a major impact on how the MPA is going to be able to influence these search engine companies and the holy grail, the ISPs, the internet service providers, which they've been going after for years now and haven't been able to get a whole lot of success with. So the DMCA, the safe harbor provision, it protects many websites and companies from having to proactively prevent illegal use of their services. But in order to qualify for this protection, the search engine has to have no actual knowledge of copyright infringement, or they should have known. That's kind of the second standard. They should have known, and if they did, the third part or third prong of the DMCA safe harbor provision is that they have to expeditiously remove the infringing content from their website. And this is where they were kind of getting into trouble because Viacom claimed YouTube wasn't doing enough to keep infringing videos from being uploaded to its site. And after doing some research and looking around, it seemed that Google really did drag its feet in installing its content filtering software about 3 years ago, at a time when sites like Facebook and other major social networking sites had already started integrating this content filtering site. Google really seemed to, and YouTube really seemed to take their time installing this software. And when it was finally initiated, about 2007 towards the end, many complained that it wasn't nearly enough to do the job it was supposed to do. Meanwhile, Viacom claims that Google and YouTube are enjoying this traffic and revenue from illegally hosted TV shows and movies. So fast forward to now, 3 years later, and here we are. We're set to go to trial at the end of this year. This thing's not even over. It's not even near done yet. You can Google it online and take a look. However, the website cnet.com reported that they allegedly uncovered the smoking gun in discovery, and that Viacom allegedly found some really incriminating emails indicating that YouTube employees themselves may have uploaded the infringing content with the knowledge of their managers at YouTube. So that would be a crushing blow to YouTube and Google, and that would really, if this was true and that comes out in discovery, they're going to have a major uphill battle at trial, and they're going to face some serious liability if that is true. So now, while this is going on, this whole Viacom versus YouTube thing, which has been going on for about 3 years now, it might not be decided till the end of this year. If it makes it to trial in 2010, there's been a number of other cases decided that have really tested the safe harbor provisions of the DMCA. One case would be Veo. The MPA sued Veo, which is Veo is almost like a cross between like a YouTube and a Hulu. It has some original content, it has some studio-generated content, and then it also has some user-generated content as well. So the MPA went after Veo a few years ago. This case was just decided towards the end of 2009, and they actually lost. And this was kind of the first defeat that the MPA had suffered. And many figure, is this a sign of things to come? Is this their first defeat? Is this going to be used as fodder in the Viacom versus YouTube battle? Or is this an aberration? Is this decision just kind of come out of left field, So again, here's Veo. It's a site that's almost like a Hulu or a YouTube. It has many different types of content. Interesting to note that Time Warner is one of the major investors. So basically the outcome of the case, Veo qualified for the safe harbor protection because in essence they did their due diligence to remove infringing content. And then many feel that it takes some of the steam out of Viacom versus YouTube. However, the MPA feels that the court simply got it wrong. But when you read the decision, the court basically comes up with, they figured that, yes, this search engine was doing enough to police its website and take infringing content from its website. The question becomes, how much do these companies have to do? And another one to mention that just came down, I think the decision came down yesterday, I'm not even sure of the title of the case, but it was in an Australian courtroom. And this was a major case, very similar to Veo, very similar to Viacom. The MPAA sued an Australian website that is almost like in effect a YouTube where people upload content to the website. And again, the MPAA lost. So that's another huge loss for the MPAA. And it could really signal the fact that they're going to have a lot less control over these search engine companies than they really wanted to. And that means that they're never going to get control of the ISPs, which is something they've always wanted to do. So who's going to come out on top? Who will be the big winner in the battle for control of 21st century media? I would bet you that the content holders themselves. And that's, like I mentioned before, a site like VO. It's owned by Time Warner. And if you listen to, there's some really good quotes online by Mark Cuban, who you might happen to be a sports fan, you might not. But if you ever watch the Dallas Mavericks, Mark Cuban is the owner of the Dallas Mavericks. He's the guy that's usually sitting on the sidelines arguing with the referees. Well, he's a pretty smart guy himself, and he's an entrepreneur. Interestingly enough, he actually financed Grokster in the MGM versus Grokster decision. So Maverick entrepreneur and Dallas Mavericks owner Mark Cuban would put his chips on a media site like Hulu that has been able to secure the necessary licenses to the content. And again, that's because Hulu's owned by all the music, movie, entertainment studios. So it's their content, you know. In essence, they're going to be able to control their content on the web. So when it comes down to a site like Hulu versus YouTube, who's going to win? And that's where Cuban's putting his chips on Hulu. Hulu has the licenses because they own the content. And because they have the licenses, they have the right to sell advertising in and around every single video on its website, and can therefore package and sell any way that it might make its customers happy. Now YouTube, on the other hand, only has that for a very small fraction of the videos and content on its website because it has very few licensing deals in place. And so for that reason, YouTube is not allowed to generate any revenue around these videos because it can only sell advertising around videos that it has licenses to. And so that's why Mark Cuban thinks that a site like Hulu is going to win over a site like YouTube that hides behind the DMCA safe harbor provisions. So now why VO, it may have some effect on the Viacom versus YouTube litigation. If CNET is correct and YouTube had knowledge that infringing content was uploaded to its site, then YouTube will be denied protection under the DMCA safe harbor provisions, plain and simple. And this would be a huge blow to Google, huge blow to YouTube, and an enormous victory for the entertainment industry in the battle for control of online media in the 21st century. However, YouTube may be a specific set of facts and may be its own precedent because people were uploading content onto the site that were employees and the managers had knowledge. So that's why they're not going to qualify for safe harbor provisions. And that's why a site like VO and a website like the Australian site is going to qualify for the safe harbor provision. So it'll be interesting to see, and there's many, many details to still unfold. However, I think we've come full circle at this point in time because with websites like Hulu.com, where you get free content, although they are moving towards a premium subscription model, and then we've just had websites on the music side of things like GrooveShark.com and FreeAllMusic.com, where they're giving away music. Free All Music, you can get 20 free downloads for a month, 5 a week. You just have to sign up. It's all free. Again, that content is licensed through the entertainment studios, so it's valid. And a site like GrooveShark is a streaming website, so you don't ever download any of the music. It's almost like a digital jukebox. You pick the song you want to play, it plays the song. So it's nice to see that the entertainment industry is finally starting to innovate slightly instead of trying to go to the whack-a-mole theory and literally suing everybody under the sun. All right, well, I'm Jason Castillo. I'm the Director of Legal Education with Attorney Credits. This is our micro-seminar on the entertainment industry's battle against online piracy. I'd like to hear from you if you have any comments, any first-hand knowledge. Maybe you've been in the trenches and working on some of these cases. Go ahead. Feel free to email me at jcastillo@attorneycredits.com. or take a look at Attorney Credits. We have a great blog. Check us out on Facebook or Twitter. Thank you very much. Have a great weekend.